Hello everyone, in this video we are going to discuss about the Telangana Assigned Lands Prohibition of Transfers Act 1977 and the Andhra Pradesh Assigned Lands Prohibition of Transfers Act 1977. Both the acts are similar and has similar provisions. So let's begin. This act consists of 12 sections. It contains definition clause in section 2, prohibition of transfer of assigned lands in section 3, consequences of breach of provision in section 4, and the provisions relating to appeal, revision, exemption, penalty, etc. The definition of assigned land is given under subsection 1 of section 2. Assigned land means lands assigned by the government to the landless poor person under the rules for the time being in force, subject to the condition of non-alienation, and includes the lands allotted or transferred to the landless poor person under the relevant law for the time being in force relating to the land ceilings. Expressed simply, it means that land assigned by the government to the landless poor person, subject to the condition of non-alienation. Non-alienation means not transferable and includes the lands allotted or transferred to the landless poor person under the relevant law of land ceiling. So, assigned land means the land assigned by the state government to the landless persons who are poor, subject to the condition of non-alienation. A mortgage of assigned land in favor of following will not be regarded as alienation. The central government, state government, or any local authority, any cooperative society registered under the Cooperative Societies Act 1994, any bank including Agricultural Development Bank, Reserve Bank, subsidiary bank to the State Bank of India, or new bank constituted under the Banking Companies Acquisition or Transfer of Undertaking Act 1970. Now let's see who are landless poor person. Landless poor person is one who does not own or has a share in ancestral or acquired land which is not more than 2.5 acres of wetland or 5 acres of dry land, and also the person engages in agricultural operations having a total income of less than 11,000 per annum, including the income of all family members. Here, the term family members does not include married son for the purpose of assignment. And next, let's see who are eligible for this assignment or the persons who are eligible for the assignment of assigned land. Only landless and poor persons who directly engage themselves in cultivation, including Harijans, backward communities, weavers, Jawans discharged on medical grounds after 5 years of service, serving soldiers, cooperative societies consisting of landless poor persons, political sufferers are eligible for the assignment. Let's see why is assigned land given to the landless poor person. Assigned land is given for the benefit of poor persons to improve the standard of living. The assigned land is given for the purpose of cultivation or a house site. So it is given for house site. They can get a house for living, and if given for the cultivation purpose, then they can have a job. Then they can do agricultural work and feed themselves. So it is given for the welfare of people in public interest. These assigned lands are allotted by the government for the welfare of people. It is given in public interest. Section 3 deals with the prohibition of transfer of assigned lands. The name of the act itself states that assigned lands prohibition of transfers. So the name of the act itself states that it prohibits transfers. So let's see what is given in the section. Where any land has been assigned by the government to the landless poor persons for the purpose of cultivation or as a house site, it is not capable of being transferred and it will be deemed ever to have been transferred. This prohibition is absolute and notwithstanding the contrary under any other law in force. So it shall mean that any land assigned by the government to the landless poor person for the cultivation or as a house site cannot be transferred. The deed of transfer or the other document relating to such land, it shall not be transferred or shall be deemed never to have been transferred. Accordingly, no right or title in such assigned land shall be vested in any person acquiring the land of such transfer. This was subsection 1 of section 3. Now let's see the subsection 2 of section 3. No landless poor person shall transfer any assigned land, or no person shall acquire any assigned land either by purchase, gift, lease, mortgage, exchange, or otherwise. This section explains that one cannot sell his assigned land, or another person cannot buy an assigned land either by purchase, gift, lease, mortgage, exchange, or otherwise. No document executed for the purpose of transfer would be valid or legal. Even the civil court cannot execute any decree in respect of transfer of assigned land. Now let's understand the section 3 with an illustration. X is a landless poor person. Government assigned a land to him for the cultivation purpose. But X transfers his assigned land to the Y person. Now here the question is the transfer valid? Does Y gets rights in the land? The answer is that the transfer will be null and void. No document executed for the purpose of transfer would be valid and legal. The deed to transfer or the other documents relating to such land, it shall not be transferred and shall be deemed never to have been transferred. Accordingly, no right or title in such assigned land shall be vested in any person acquiring the land by such transfer. So consequently, no right or title in such assigned land will be vested in the transferee of the assigned land, as the transfer will be deemed to be null and void. Here there is an exception to the prohibition of transfer of assigned land. If the assigned land which was purchased by a landless poor person in good faith for the valuable consideration from the original assignee or his transferee prior to the commencement of this act, which is in the possession of such person for the purpose of cultivation or a house site on the date of such commencement. So this is an exceptional clause, is only applicable to those transfer of assigned land made prior to the commencement of the act. Section 4 deals with the consequences of breach of the provision of Section 3. So if the district collector or any other officer not below the rank of Mandal Revenue Officer is satisfied that the provision of Section 3, subsection 1 of the Act regarding the prohibition of transfers etc. have been contravened in respect of assigned land, the following consequences may follow. Taking the possession of assigned land after evicting the person transferee thereof in unauthorized possession. The possession of assigned land is taken and by evicting the person who is in unlawful possession. And next is restoration of assigned land to the original assignee or his legal heirs. If such restoration is reasonably not practicable, resumption of assigned land to the government for the assignment of land to the landless poor person. However, the assigned land shall not be restored to the original assignee or his legal heirs than once. This bar has been imposed to prevent the continuous violation of the provision of the Act. The restoration of land. The right of assignee to seek the restoration of land after the resumption, even if he continues to be eligible, that is, the landless poor person, is not absolute. If such assigned land is required by the government for any other public purpose or for the public interest, the government decides to reserve the land for the future expansion of the project, etc., then the assignee cannot compel that the authorized officer or any government officer to restore the same land. Section 4A and Section 4B consist of appeal and revision. If a person is dissatisfied by the order passed by the Mandal Revenue Officer, may appeal within 90 days from the date of receipt of such order to the Revenue Divisional Officer. few tariff is also dissatisfied with the decision made by the revenue divisional officer, then within 90 days he can appeal to the district collector. The district collector may, in respect of any proceedings, accept the appellate proceedings before him, either on an application. Section 4. The district collector may, in respect of any proceedings, accept the appellate proceedings before him, either on an application. Section 4b is of revision. The district collector may, in respect of any proceeding, accept the appellate proceedings before him, either on an application made to him or on his call for and examine any record of subordinate officer. He may either approve or modify such orders and even remit the same to the decision making authority for reconsideration while exercising this revisional jurisdiction. Here, the principles of natural justice have to be followed. The limitation period for exercising such revisional jurisdiction is 90 days from the date of order, so revised. The section 5 is of the prohibition of registration of assigned lands. Generally, the transfers are not prohibited, but the section 5 prohibits the registration of assigned lands. Nowadays, it is common to find in almost all the sale gift exchanges being registered a clause stating that the transfer is not prohibited under the Act of 1977. This is because under Section 5 of the Act, no registering officer is competent to accept the registration of any document relating to transfer of assigned land. In fact, the state government is required to furnish a list of assigned land to the registration. In fact, the state government is required to furnish a list of assigned lands in the district to the registering office for the purpose. The assigned land can be transferred by registration only after obtaining the prior permission of the district collector, probably subject to the provision of Section 4 of the Act. So, this renders the Registration Act inapplicable to the assigned lands. No registering officer shall accept the registration of any document relating to transfer of or the creation of interest in any assigned lands as furnished in the list. Section 6 consists of exemption. So this act is not applicable on the assigned lands held on mortgage by the state government or central government or any local authority or a cooperative society, a scheduled bank or other financial institutions owned, controlled or managed by the state government or central government as may be notified by the government on this behalf. Section 7 of the Act states the penalty. If a person acquires any assigned land in contravention of the provision of subsection 2 of Section 3, which means that no landless poor person shall transfer any assigned land and no person shall acquire any assigned land either by purchase, gift, lease, mortgage, etc., exchange or otherwise, shall be punished with the imprisonment which may extend up to 6 months, with fine up to 2000 rupees or with both. And next is if a person is against the district collector or any authorized person in taking possession of assigned land under this act shall be punished with the imprisonment up to 6 months or with fine which may extend up to 5000 rupees or both. So let's understand with an example. If a person unlawfully re-enters and occupies a assigned land from which he was evicted, shall be punished with the imprisonment which may extend up to 6 months or with fine up to 5000 rupees or with both. If any officer is violating the provisions under the subsection 1 of section 2 of section 5, shall be punished with the simple imprisonment which may extend up to 6 months, fine which may extend up to 10,000 rupees or with both. Here no court shall take cognizance of an offence punishable under this section. except with the previous sanction of district collector. Here the section 8 is of the protection of action taken. No suit or prosecution or other legal proceeding shall lie against any person, officer or authority for anything which is done in good faith or intended to be done in the pursuance of the act or any rules made. Here no suit or legal proceeding shall lie against the person or the authority for anything which is done in good faith or is followed under the rules of this act. No suit or the other legal proceeding shall lie against the government for any damage is caused or which is likely to caused for any enquiry suffered or likely to be suffered by the virtue of the provisions of this act for anything which is, if anything is done in good faith or intended to be done in the pursuance of this act or any rules made thereunder. The section 8 states that no suit or prosecution or other legal proceeding shall lie against any person or officer or authority or also against the government for anything which is done in good faith or intended to be done in the pursuance of the act or any rules made under. In other words, the assigned land means a land assigned by the government to the landless poor person subject to the condition of non-alienation. Such assignment denotes the grant of land at the disposal of government to the individuals, institutions, and firms either on the payment of value or free of cost. If they pay valuable consideration, there is a chance that assigned land can be transferred. But under this act, assignment of government wasteland to the landless act is for the assignment of government wasteland to the landless poor person. Such assignment was made with a condition that such lands cannot be. So this act is for the assignment of government wastelands to the landless poor persons. Such assignment was made with a condition that such lands could not be alienated, and it is found to be alienated, the government could resume the same. However, from the past experience has shown that the substantial amounts of land which has been assigned to the landless poor persons have actually been alienated and ended up with the hands of the well-to-do persons. Since such nations defeat every object which the assignment has been made, the government has brought a protective legislation which culminated in the form of the present act. This act is a retrospective in operation and applies to the transactions of sale prior to the commencement of the act. And further, the alienee cannot plead adverse possession if he did not perfect his title by adverse possession by the time of the act came into force. So in brief, this legislation is a protective legislation and has been enacted for the protection and the benefit of genuinely landless poor persons. I hope that the concept of assigned land is clear to you. And if you have any questions, doubts or suggestions, leave that in comment section. If you have not subscribed yet, consider subscribing.